Now we're going to discuss about workers' compensation and how worker compensation is affecting other laws that we have, again, to protect the individual. This is in the workforce, nothing else. An example would be a nurse that is pregnant and she has to work with a patient that has AIDS, and therefore she rather not work with patient that have AIDS, so she files a claim of workers' comp to be released from that situation. And of course the employer doesn't agree with it, and he wants her to work in the floor with the patient that have AIDS. And the thing that was very interesting, she doesn't want to take any risk. That she has the freedom here. No, she does not have the freedom. And the interesting part in this case was that the court says, wait a minute, whether a nurse is pregnant or not pregnant, they are taking a risk of working with patients that have AIDS. Therefore, the employer has no obligation to provide or to move her to another department, because first of all, the baby to come, it's not a responsibility of the employer. He has no obligation to the next generation. He has no obligation whatsoever to the unborn child. And this was very interesting. And just to share you something like that, where, you know, you're an employee, fine, I can protect you, but anything else outside, you're not. So here is another case that you probably heard, and it was very interesting how, again, workers' comp is affecting. Here is the employer trying very much to save life, to protect safety, to make sure that you don't get hurt while you're working. And next thing you know, by doing that and getting some information, then the employer will be able to, will violate another law. In your one of the interesting case that you have in your chapter is the Johnson case, which was another very interesting situation where the employer made a policy that women that are pregnant, or let's say not even pregnant, women of an age that could become pregnant, will not be able to work in certain department because they might be exposed to lead. Well, next thing you know, the women discrimination, because wait a minute, you know, just because I might become pregnant and I have the opportunity to be able to have children, where is it the study that the man, it's okay to be exposed to lead and not the woman? So in that situation, here is Johnson drafting or enforcing a policy to protect the women so that their unborn child, if they become pregnant, all the women that are a certain age, for anything from 20 to about 45, could not work in certain area of the business because they might be exposed to lead. Well, what about the men? And in that situation, again, the company lost. Here they're trying to protect the women to make sure that they don't have deformed children, and we have enough evidence of that, but somehow that was discrimination. So that was interesting. Here is another case that I thought was very interesting, and that is Exxon. And you know that when the supertanker Exxon Valdez hit the reef in Prince William Sound, Alaska, in 1989, and it caused one of the worst oil spills in history, that to this day, they own about $15 billion, or $50 million to Alaska, and they did not pay yet. Exxon faced extensive liability under the environmental laws. Okay, so here is something where they are really in a bad situation, and they to pay for the cleanup. It was widely believed that the captain of the tanker was intoxicated at the time of the accident. So here's the Exxon right away, what it's doing to make sure this doesn't happen again. Anybody that has any history of alcoholism or anything to do with substance, of drugs, anything to do, will not become or be a tanker captain or work in certain other safety sensitive position. They were not allowed. But then for them to find out about this, they would have to what? Ask questions. So Exxon policy was designed to minimize accidents and shield the company from liability under the environmental laws, because we don't want this to happen again. We don't want to have oil spills. We don't want to do it. So is Exxon policy violating another law? You bet your life it is. In 1998, the Equal Employment Opportunity Commission claimed that Exxon had violated the American with Disability by discriminating against some 50 employees who were rehabilitated substance abuser. When you have a disability, has nothing to do with the performance of your qualification. the employer cannot ask you a question. The federal court agreed and held that Exxon could not discriminate against such employees unless it could show that they pose a direct threat to the health or safety of others. Just because they are rehabilitated alcohol people does not mean that they are going to be drinking while they are captain of a tanker. That was an incident. That was an accident, if you want to call it. So they violated the discrimination of the American with Disability law. Another one, prior to the American with Disability, many employers had the policy to require that the employees be capable of performing the full duties of a position 100% in order to be returned to work. So before the American with Disability law came, which is an act again from Congress, the purpose of that act was because many people on SSI really could work. And since we don't want to pay more taxes, and this is, again, trying not to increase taxes, they tried they set up this law so the company would have to hire people with disability and making reasonable accommodation, you know that. So before this act came, before 1990, if you could not work full duties, then you could go on workers' comp, and that's all there is to it. Under the ADA, employers must make reasonable accommodation for those workers who can otherwise perform the essential function of the job. Under workers' comp, that's it. You can retire if you want it, and you get your workers' comp, and maybe you can work on something else or do something else. But the employer does not have to rehire you back. Where under the American with Disability, he does, and he also has provided reasonable accommodation. So, an example, a supermarket meat cutter who was out on work compensation for a back injury and who's released to return to work by his or her physician may be found to be able to perform all the functions of a job except for being unable to carry meat from the loading dock to the processing area. So what does then the employer under the American with Disability has to do? The supermarket can no longer flatly refuse to return this individual to work without being in violation with the ADA. If they don't take him back, they will violate the American with Disability. It would have to make available a card or a device to enable this worker to perform the unloading function. Where under workers' comp, the employer didn't have to do it. So you know that this will be a lot more expensive for the employer, for the business. So please post your argument on the bulletin board, because I want you to, what is your view about it? How you see this conflict between the new law of American disability and workers' comp? And again, how can the employer comply with one law without violating another one? Thank you.